basic term. So basically now let's understand the contractual agreement structure. So at the center of every contract is a simple equation. What is the equation? That contract is equal to agreement plus enforceability. But for an agreement to evolve into valid contract, certain conditions must be met. What are the conditions? The first one is there must be free consent. Free consent means no force, no fraud, no pressure. Second point is that parties should have a lawful consideration. What does it mean? Right, it means something of value should be exchanged. Third thing is that party involved should be legally competent. Fourth point is that the object or purpose should be lawful also, and it must not be declared void under the Indian Contract Act 1872. So these are the conditions which should be followed for an agreement to evolve into valid contract. 5 conditions I have told you. Right, now let's clear a common confusion. Remember, all contract are agreement, but not all agreement are contract. Very important point. All contract are agreement, but not all agreement or contract. Why? Because validity depends on enforceability under the law. I told you now there are some conditions under which agreement can become contract. Now friends, finally the essential of contract include a legal obligation, a mutual assent of parties, and recognition under the law. So a well recognized, well structured contract is like hitting the bullseye. It aligns intention, legality, and accountability. So these are the important points regarding contract. Now have a look at the next slide. That is, let's explore one of the foundational limitation in the contract law, that is called minor capacity to contract. So in this particular slide we will cover everything that is regarding this minor capacity to contract. So this principle was firmly established in the landmark case of Mohri Bibi versus Dharmodas Ghosh, which set the precedent that a minor contract is void ab initio. What does it mean? It means that it is invalid right from the beginning. So void ab initio means it is invalid right from the beginning. Right, now under section 11 of the Act, Indian Contract Act, a minor is not a competent party. Therefore a contract with a minor has no legal standing. There is no obligation to refund any benefit that is received. However, a guardian can enter into a valid contract on the behalf of minor if it is for the minor's benefit. Right, so these are the important points. Again I am repeating, a contract with a minor has no legal standing. There is no obligation to refund any benefit received. However, a guardian can enter into a valid contract on the behalf of minor if it is for the minor benefit. Now the capacity is not just about age, it's about mental stage. Right, mental state. A person must be of sound mind to contract, which means they must be able to understand the terms and make a rational judgment about its effect on their interest. Now here is the key part. If someone is usually of unsound mind but was of sound mind at the time of contract, then it is valid. Conversely, if someone is usually of sound mind but was unsound at the time of contract, that is not valid. Again I am repeating, someone is of unsound mind, right, usually of unsound mind, but was of sound mind at the time of contract, it is valid. But someone who is of sound mind but was unsound at the time of contract, that is not valid. Now let's look at some simple illustration. A lunatic who experience interval of sanity can make valid contract during those interval, but someone who is delirious due to illness or intoxicated cannot contract while in that stage. So to summarize, the legal capacity, whether by age or mental soundness, is non-negotiable in the eyes of contract law. I hope the concept is clear now. Now friends, have a look and understanding on the contract of indemnity. Every important point we are covering here, right friends? So if you want such kind of PDF through which you can revise the entire content in very short time, you can enroll in our crash course program, detail regarding which you can find in the description section of the video. First of all, have a look at the implied indemnity. So unlike express indemnity, which is clearly stated in a contract, implied indemnity, what does it mean? It arises not from words but from conduct or the nature of the relationship. Right, so it steps in silently, offering protection when one party suffer a loss after acting at the request of the other. Right, so the core idea is, if you act on someone's request in good faith and that act unintentionally cause harm or trigger liability, you have the right to be indemnified. Right, importantly point is that the act must not have been knowingly or wrongful at the time it was done. So let's understand this with a real life case. right? So one example given in your book, which is so one example is given, as you can see, Secretary of State versus Bank of India, right? A bank issued a renewed government promissory note based on forged endorsement by a broker. Later, the true owner sued the government. The government, having acted on the bank assurance, sued the bank. The government sued the bank. The court held that the bank liable to indemnify the government even though there were no express agreement. So this is the classic example of implied indemnity, where action, not word, establish the legal duty to make good the loss, right? So that is about the implied indemnity. That is what we talked about, right? Unlike express indemnity, which is clearly stated in a contract, implied indemnity arises not from word but from conduct or the nature of relationship. As you can see, it arises from the conduct or nature of relationship. It steps in silently. That's why it is called implied, offering protection when one party suffer a loss after acting at the request of the other, right? So that is the main point, right? So let's understand. I told you an example, right? Now have a look at the contract of indemnity. So in this slide we will understand the contract of indemnity as per section 124 of the Indian Contract Act. ICA means Indian Contract Act. A contract of indemnity is where one party, called the indemnifier, promises to protect the other, known as indemnity holder. So indemnifier promise to protect the indemnity holder from a loss. So this loss can arise from the action of the indemnifier or even from the third party. But here is the key. Actual loss must be proven for any claim to be valid, right? So to understand better, let's take a simple illustration. Like for example, A promised to indemnify B against any claim made by C. So that is right here. This right here is called contract of indemnity, right? So section 124 you must remember, and one party who is called indemnifier, he promised to protect the indemnity holder from a loss. And this loss can arise from the action of the indemnifier or even from the third party. Like A is indemnifying B. So A is the indemnifier, B is the indemnity holder, right, against the claim made by the C. Now, what are the rights that indemnity holder have? Have a look. So first of all, they can recover all damage that they have to pay due to the indemnified matter. Second, if they have incurred legal cost and have either followed the instruction of the indemnifier or acted prudently, they can claim that also. Third point, any compromise sum paid within the terms of the contract, they are also recoverable. And finally, the indemnity holder can even sue for a specific performance if they have taken on absolute liability under the agreement. So remember, indemnity is not always written, but when fairness demand it, the law imply it, right? So in simple word, a contract of indemnity is like a legal umbrella. It shields the indemnity holder from the financial consequence of someone else's action. Now have a look at the contract of guarantee. So implied indemnity, I told you what is the meaning of implied indemnity. Have a look at the contract of guarantee. In this slide, the concept of contract of guarantee will be clear. So friends, it is an important safeguard in the world of business and finance. At its core, a contract of guarantee is when, surety that is a third party, promise to pay if the principal debtor default. So if the principal debtor default, surety, who is the third party, they promise to pay. This means if the borrower fails to pay, the surety will steps in. So surety will pay if the borrower fails to pay. That is the main point, right? So this contract is not just one agreement, rather it is actually two separate contracts. So two separate contracts are there: an express contract between the creditor and the surety, an implied contract between the debtor and the surety. So remember, this contract is not just one agreement, rather it is two separate contracts: express contract between creditor and surety, and implied contract between debtor and surety. So let's understand the key parties who are involved here. So if you look at the key parties, as you can see here, so the first one is surety, means the person who give the guarantee. Then we have principal debtor, means the one who owe the money and carry the default risk. And the third one is creditor, means the person or the entity to whom the guarantee is given, right? So surety gives the guarantee, principal debtor is the person who owe the money and carry the default risk, and the creditor is the person or entity to whom the guarantee is given. Now a few essential rule here. So friends, a contract of guarantee must be supported by a valid consideration, right? Even if that consideration exists solely between the debtor and the creditor. Second point, the surety liability arises only when the debtor default, not before. Third point, and crucially, once the surety makes the payment, they have the right to recover that amount from the principal debtor. So in simple term, if we summarize, the contract of guarantee is a safety net for the creditor and a strong commitment from the surety. It ensures trust, it ensures continuity in the financial relationship. Now have a look at the surety liability structure. This is very, very important thing. Questions are asked every year. So it is a crucial component of the contract of guarantee. So at the heart of this concept is the core rule. Have a look at it. So the core rule says that the surety liability is coextensive with that of principal debtor. It means that surety is liable for the entire debt, including interest, penalties, and any default charge, unless a specific limit has been agreed upon. Now let's talk about the right of the surety. So once the surety has paid off the debt, they gain the right of subrogation. What is the meaning of subrogation? Means stepping into the shoes of the creditor and gaining the legal right to recover the full amount from the principal debtor. That is called right of subrogation. Means the surety can step into the shoes of the creditor and can gain the right to recover the full amount from the principal debtor. At the same time, surety has the power to limit their liability. For instance, they can agree to be liable for a maximum of rupees 50,000, even if the debtor end up owing 80,000. So that is called limit their liability. This has the surety has the power. But here is something more important. The surety cannot delay or avoid action by the creditor by claiming the debtor is insolvent, or that other remedies are pending, or that creditor has not yet tried everything against the debtor. In short, no defense can delay creditor right to act. That is the point. Means surety cannot delay or avoid action by the creditor by claiming that debtor is insolvent, or that remedies are pending, or that creditor has not tried. Means no defense can delay the creditor right to act. So this is all about, we have discussed that surety liability structure, right? So we have discussed subrogation, right of subrogation. We have discussed limiting liability and no defense against the action. Now have a look at what is the status of the guarantee. Very, very important. So status of the guarantee. Let's now explore an important aspect. What is the status of guarantee over the time? So there are three key dimensions to understand here. So basically there are three key dimensions we will understand here. So first is the revocation, second is the continuing guarantee, and the third is the death of surety. So let's start with the revocation by surety. A surety can revoke the guarantee for future transaction by giving notice to the creditor. But here is the catch. The catch is that past transactions still remain valid and the surety remain liable for them. So they can give a letter to the creditor saying that I am not liable for the future action. But there is a catch, that past transactions still remain valid and the surety remain liable for that. And also the limitation period is there, which is the window during which a claim can be made, started from the demand date. Now have a look at the continuing guarantee. So friends, unlike a one-time guarantee, a continuing guarantee covers a series of transactions. As the name itself suggests, it is a series of transactions. For example, a husband give a 20,000 credit limit for his wife purchase. This is not a one-off. It is a continuing guarantee, valid until explicitly revoked. For example, a husband give a 20,000 credit limit for his wife purchase. So this is not a one-off, it is a continuing guarantee. So unlike a one-time guarantee, a continuing guarantee covers a series of transactions. And the third thing is death of surety. So upon the surety death, the guarantee automatically revoked for future transaction unless the contract clearly states otherwise. However, any past obligation still hold, the liability does not vanish. So creditor have a strong right. So what we learned from this discussion is that creditor have very strong right. They can proceed directly against the surety, and this remain true even if the main contract is later found to be void or voidable. I hope it is clear now. So to summarize, being a surety is powerful but serious responsibility. It offer right but also bring with significant obligation. Now have a look at the next slide. Very, very important. So what are the implications of co-surety release and subrogation, right? So basically co-surety, release and subrogation. So let's talk about two powerful concepts. The first thing is co-surety release. Whenever there are multiple sureties involved, releasing one of them does not discharge the other. Whenever there are multiple surety involved, releasing one of them does not discharge the other. That is right. Even the released surety remain liable to the co-surety, meaning responsibility is shared and cannot be dogged simply by being released from the creditor. So suppose for a particular guarantee, three, four sureties are there, multiple sureties are there, right? So if you release one of them, does not discharge the other. Even the released surety remain liable to the co-surety. It means responsibility is shared and cannot be dodged simply by being released from the creditor. Now have a look at the surety subrogation. Subrogation is a legal superpower for the surety. Once the surety has paid off the creditor, they don't walk away empty-handed. Instead, they step into the shoes of the creditor. They now hold the same right the creditor did. This means the surety can recover the amount paid from the principal debtor. That is called principle of subrogation. It is based on legal principle of subrogation, which ensure that surety is not at the loss after fulfilling someone else's liability. So while co-surety share burden, but subrogation ensure that surety is not left carrying it alone. So these are the two important. So what are the implications of co-surety, release and subrogation? I think it is clear now. Now friend, have a look at the bailment. Very important discussion we are going to discuss now. So friends, let's look at the concept of bailment, a term that plays a key role in the commercial and contractual law. First of all, what is bailment? So bailment means delivery of the movable good. So delivery of the movable good by one person who is called the bailer to another person who is called the bailee for a specific purpose. So basically goods is being moved, movable goods is being moved, movable goods is being delivered from the bailer to the bailee. Right? What is the purpose of this bailment? It is not just about handling over the good. It is done for a specific reason under a contract. And once the purpose is fulfilled, the goods must be returned or disposed of as per the instruction of the bailer. So bailer is one who is delivering, bailee is one through whom it is delivered, right? And the purpose is clearly written. It is for a specific reason. So friends, purpose of bailment is not just about handling over the goods. It is done for a specific reason, right? Once the purpose is fulfilled, the good must be returned or disposed of as per the instruction of the bailer. If we look at the nature of the contract, so what is crucial here is the possession, right? Not the ownership. Even if there is no formal contract, like in the case of someone finding lost good, bailment can still arise if possession is taken with responsibility. So this is very crucial here. Possession is very much crucial here, right? Not ownership. Which means even if there is no formal contract, right? Even if there is no formal contract, like in the case of someone finding lost good, is there any contract? No. So bailment can still arise if possession is taken with responsibility. Now if you look at the bailee's obligation, so the bailee's responsibility begin from the contract, not from the ownership, not from the status. They are expected to return the good on the due date without any reminder or demand. Now there are some exceptions. Of course, not every handover is bailment. There are specific exclusions. Some situations simply do not meet the legal condition to be treated as bailment. Now let's explore another aspect, that is called pledge, right? Have a look at the pledge. So friends, pledge hold its validity in different scenario, an essential concept when dealing with guarantees and security. So first side we have pledge without possession. So pledge without possession is considered invalid. It means the pledgee must hold the pledge good to secure the loan. The pledgee must hold the pledge good to secure the loan. However, in some case, custody for a purpose is allowed, such as when the goods are kept for business use. For example, the Bank of Chittor versus Narsim Bulu, right, 1966. What happened? In this case, a cinema projector was placed, but the pledger was allowed to keep it for the business purpose. Later, when pledger sold the pledged good, the sale was still subject to the bank prior charge, highlighting that pledgee right over the pledged property, right? So that is the main point, that what I told you, that a pledge without possession is considered invalid. It means pledgee must hold the pledge good to secure the loan. However, in some case, custody for a purpose is allowed, right? So this is called pledge without possession. And then pledge by pledgee. When the pledgee replaces the property, it is valid only to the extent of pledgee interest. For example, in the case of Thakur Das versus Mathura Prasad, right, the court ruled that original pledger retained the right to the property upon repayment of the original loan, right? However, if original pledge is invalid, then the repledged itself become void. This was illustrated by the Jaswant Rai Manilal Akane versus State of Bombay case, where an invalid pledge invalidated the repledge as well, right? Part of the contract of sale, basically it is an agreement where goods are sold in exchange for money. So look at the definition. First of all, goods. So question may be asked, these are movable thing, right? Movable property like crop, like shares, like stock, but not money or things like legal claim. So remember, it includes stock, it includes share, growing crops, grass, land part to be severed. So this is called goods. Now the price. What is the price? Price means the money you pay for the goods. Then we have delivery. Delivery means what? The good must be handed over willingly. It is a voluntary transfer of possession. Then we have seller. Seller, as you can see on the right hand side, seller. Seller is the person selling or agreeing to sell. Then we have the buyer. Buyer is the person who is buying or agreeing to buy, right? Then we have a specific contract. So what is the meaning of a specific contract or a specific goods? First of all, a specific goods. So these are the goods clearly identified at the time of contract. So some goods are clearly identified at the time of contract. Like suppose I want that blue sofa. This is the kind of a specific goods. Then we have something called future goods. So what is the meaning of future goods? So future goods means things that will be made or grown later, like crop, like custom made table. Then we have documents of title to good. What does it mean, documents of title to good? See, a paper or a proof that shows you legally control or possess the goods. Things like bill of lading, warehouse receipt, war finger certificate, rail receipt, multimodal document. So this is a paper or this is a proof that shows you legally control or possess the good. That is called document of title to good. Then we have mercantile agent. So these are the business agent who can sell, buy, or even get loan using the goods. So agent can sell, they can buy, or they can get loan, they can raise money on the basis of goods. So in short, if we summarize, a contract of sale is like a promise with clear role, buyer, seller, good, price, delivery, all tied together by a legal agreement. And every aspect we have covered, what are included in goods, what is price, what is delivery, voluntary transfer. So this keyword you must keep in mind. Now have a look at the contract of sale. This diagram will clearly tell you every aspect of it, right? So have a look at the contract of sale. So a contract of sale is like a legal deal where a seller transfer good to a buyer for a price. Let's see how it works. So it is a two-way deal. It is a kind of two-way deal. First of all, there are always two parties involved. This is called bilateral. Two parties are involved, right? The buyer and the seller, the one who sell and one who buy. It is quite simple. Then it is all about money, right? Money consideration, which means basically the consideration must be money, not barter or exchange. Only then it is a valid contract of sale. So money consideration is there. And it covers movable property only. We are talking about thing you can move, like furniture, electronic. What about land and building? So land and building, they are different law. That is the Transfer of Property Act. So land and building are not covered under the contract of sale. Now there is no fancy paperwork needed, right? So a sale can be written, it can be oral, it can be spoken, or it can be even understood through action, as long as there is an offer and acceptance. So this is the very important. It can be oral, it can be written, no need to paperwork. And that flexible delivery and payment, this is very important. So the contract can allow immediate delivery plus payment, or delivery or payment in installment, or even postponing the both. Now the question is, what happened after the contract? See, it is if the property is transferred, it is a sale. Very important part I'm telling you, right? If the property is transferred, it is called sale. But if it is not, it is called agreement to sell. This is very important aspect. If the property is transferred, as you can see, if the property is transferred, it is called sale. But if it is not transferred, it is called agreement to sell. So this is what happened after the sale. If it is not transferred, it is called agreement to sell, and the actual sale will happen later. So in short, if we summarize this contract of sale, it is a flexible money based deal between two people only for movable goods and can happen in many way, but always with clear agreement. So see, what is the peculiarity of this slide is that just before the examination, if you go through this slide, you will be able to cover all the important points, and if any question is asked regarding any points of the contract of sale, you can easily answer. So this is the power of the mind map. You can easily recall, and if you want such kind of content, you can enroll in our crash course program, because in crash course we only provide you such kind of content which help you quick revision, fast revision, and our focus should be on MCQ solving. In the description section of the video you will get the link. Now have a look at the contract of sale and related concept. So let's look at this particular slide. So the contract of sale is more than just a simple buy sell deal. Let's break it down step by step. So if you look at the types of contract of sale, we have absolute sale, means the goods are transferred immediately, and we have conditional sale, which means goods are transferred only after some condition is fulfilled, like payment or delivery, right? So this is called conditional sale. And name itself suggests absolute means what? Goods are transferred immediately. Conditional means what? Goods are transferred only after some condition is fulfilled. And this can happen before the contract, which we call pre-contract, or it can happen after it is signed, called the post contract. Now one more important thing, does time matter? Yes. Time of payment is not crucial, right? Time of payment is not crucial unless clearly mentioned. And other time terms, yes, they depend on what is written in the contract. Now the question is, what if the sale happened with a problem? Yes, what if the sale happened with a problem? If the seller get possession of the good through fraud, misrepresentation, coercion, or undue influence, right, the contract is voidable. Right, the contract is voidable. Very, very important part. Remember, the contract is called voidable contract if you get possession of good through fraud, misrepresentation. But if the buyer did not know about the issue, buyer is in good faith, he did not know about the issue and bought in good faith, so then the buyer get a valid title to the good. Very, very important aspect. So contract is voidable if the seller get possession of good through fraud, misrepresentation, etc. But the buyer did not know about the issue and bought in good faith, then the buyer get a valid title to the good. This is very important aspect, right? So that is called voidable contract possession. Now have a look at agreement to sell versus sale. See, if the ownership is said to transfer in the future or on fulfilling a condition, it is just called agreement to the sale. So if see what I'm telling you, if the ownership is said to be transferred in the future, it has not been transferred now, right? So if the ownership is said to transfer in the future or on a fulfilling a condition, it is called agreement to sell, and once that happen, then it becomes sale. So in a nutshell, if we summarize this particular diagram, we can say a contract of sale has many layers. It can be immediate, it can be conditional, time or may not matter, and ownership can be affected by the hidden flaw, but good faith buyers are protected. I hope it is clear now, right? Now have a look at this particular table. It is just taken from your book, sale and agreement to sale. This difference should be clear. Very, very important. Have a look at it. So let's clear the confusion, sale versus agreement to sale. So when you are buying or selling good, the timing of the ownership and the right really matter. So what is the real difference between sale and agreement to sale? First of all, sale means what? Deal is done, and agreement to sale means what? Deal to be done. So have a look at the sale. On the left hand side you will see the sale. Sale means the deal is complete, both sides have done their part. Ownership of goods has already passed to the buyer, no matter if delivery is done or not. And the next point is, if anything happened to the goods, buyer bear the risk. If the seller failed to deliver, the buyer can go to court and demand delivery of performance, and if the buyer does not pay, the seller can sue, stop delivery, or even resell the goods. Now have a look at agreement to the sale. It is a promise for a future deal. Both parties still have to perform. Ownership of goods will be transferred later only after conditions are met, like full payment or future delivery. Until then, the risk is still with the seller. If the seller failed to deliver, the buyer can only claim damage, not force delivery. So, and the last point is, seller can resell the good yet, but if the buyer does not pay, the seller can sue to get the good or the price. In simple word, you can think of sale as handing over the key and walking away. It is done. But an agreement to sale is like a promising to hand over the key later. We have not handed over the key yet. We will hand over the key later. The deal is not complete yet. That's why I told you, agreement to sale is like a promise for the future deal. Both parties still have to play their part. They have to perform. Ownership of good will be transferred later only after the conditions are met. And if the seller failed to deliver, the buyer can only claim the damage. Right, these are the points. Now have a look at the contractual stipulation and the buyer option. See, let's break down the key part of a sale contract and what buyer can do if something goes wrong. First of all, condition. You can think this condition like core promise of the contract. If it is broken, the buyer can cancel the deal and reject the good. This is called condition. Condition means core promise of the contract. If it is breached, the buyer can cancel the deal and reject the good. For example, you order a refrigerator and they send you microwave. That is called broken contract, isn't it? So you can think the condition as the core promise. We are talking about sales contract, right? So it is just like a core promise of the contract. If it is broken, the buyer can cancel the deal and reject the good. Just now I have given you example. What about warranty? Warranty is a side promise, not the main deal. If the warranty is broken, the buyer can claim damage, which is the money, but can't cancel the contract or return good. Right? So if, for example, if the fridge you order comes with a tiny scratch, so that is a warranty issue. That is not a condition issue. I hope the difference between warranty and condition is clear. Now, just like I told you, if you order refrigerator and they send you microwave, that is called broken condition. But warranty is a kind of side promise, right? Core promise means condition, side promise means warranty, right? You can't cancel the contract in the case of warranty, but in the case of condition, the buyer can cancel the deal and reject the good. Now, contract nature. See, sometimes a term may be called a warranty but actually be a condition if it is essential to the contract. So level does not always define reality. What matter is how important the term is to the deal. So condition and warranty, the difference should be clear. Now, buyer's choice. The buyer has the power to waive a condition and treat it like a warranty. Once claim damage and continue the contract. So flexibility input into picture. Now question is, what if the buyer accept the good? See, if the buyer accept the good even with a problem, it is treated as a warranty breach, which means just damage. Buyer can't reject good later unless the contract say otherwise. So once you accept, your choice narrow, so inspect carefully. So this is very important point. So to wrap it up, let's summarize the point which we have covered. See, condition means cancel plus rejection. Warranty means damage only, and the buyer choice makes all the difference. If you buyer accept, then there is he cannot tell in the letter that no, I will not accept it. If he has accepted, then it is expressed, right? That is the point. If the buyer accept, it is treated as a warranty breach. Buyer can't reject the good letter unless the contract say otherwise. So I hope this concept is clear now. Now have a look at this particular case, that is called the right of the unpaid seller. So when a seller does not receive payment for the goods sold, seller has sold the good, but he has not received payment. There are legal protection in place to safeguard their interest. So let's take a look at those rights. First of all, unpaid seller, section number 45. So what is that? What does it mean, unpaid seller? So unpaid seller is someone who has not been paid for the goods sold. He has sold the good, but he has not been paid. So this could happen if the price is not paid or if the check is dishonored. So these apply to the seller, agent, endorser or consignor. Then we have right against the goods. So the unpaid seller, they can take certain action regarding the goods. First of all, lien. Lien, if the buyer has not paid, the seller can retain possession of the goods. Stop in transit. If the goods are on their way to the buyer, the seller can stop them before they reach the buyer. The seller can resell also. The seller can also resell the good if the buyer has not paid. So these are the action that the seller can take against the good. Now right against the buyer. If the payment is not made, seller can take legal action against the buyer, like suit for price, ask for the price of the goods in the court, suit for damage, claim damage for the failure of payment, repudiation of the contract, means seller can cancel the contract, and also suit on interest. Thus, if the seller has to wait for payment, they can claim interest. Then unpaid seller lien. The seller has a right to retain the goods if no credit, means buyer had not paid and there is no credit agreement. Second condition, credit expired, if any credit extended to the buyer has expired. Third condition, buyer insolvent, if the buyer has become financially insolvent. In these three cases, no credit expire, buyer insolvent, the seller has right to retain the goods. The seller lien also apply when part deliver of the good is made, and unless waived, they can hold on to the remaining balance. So to summarize the fact which we have learned in this slide, let me tell you, the seller can claim their right over the good if the payment is due. First point, the seller can take legal action against the buyer if it necessary, and the seller always has protection in place ensuring they get what they're owed. So I hope this make your concept clear. Now have a look at the right of the unpaid seller, very important aspect. using this diagram. So friends, when an unpaid seller has not received payment, they have the right to stop the good in transit. Let's break it down into simple terms. First of all, right of stoppage in transit. If the goods are on their way to the buyer, then payment has not been made, the seller can stop the good in the transit. This means the seller can stop the carrier from delivering the goods to the buyer. Right, then it is clear. Now when does the lien end? That is called termination of lien. Try to understand. The seller right to stop good in transit end under certain condition. First of all, when the buyer take the possession, right, which means what? Buyer take possession means once the buyer or their agent has possession of the good, the seller lien is lost. Right, first condition, that is called buyer takes possession, as you can see written here. Second point, buyer insolvent. What is the meaning of buyer insolvent? So if the buyer become insolvent, means unable to pay their debt, the seller can exercise their right to stop the goods. And there is something called decree for price. So what is the meaning of this so-called decree for price? As you can see written here, see, if the seller has legal decree, which means court order, if the seller has court order demanding the price, they can still stop the good in transit. And there is something called lien waived. What is the meaning of lien waived? If the seller waives their lien, which means gives up their right, they cannot stop the goods anymore. That is the point. Now if we talk about the duration of the transit, have a look. So the goods are in transit from the time they leave the seller hand until the carrier takes the good. Means the goods are officially in transit when handed over to the carrier, such as shipping company, or it ends when buyer takes the delivery. The goods are considered no longer in transit once the buyer receives them. Now the question is how to stop in transit. To stop the good in transit, the seller must notify the carrier or the bailee. Bailee is the person or company holding the goods, that they are stopping the delivery until payment is made. And this notice to carrier or bailee let them know to hold on the good. So to summarize the fact which we have learned in this particular slide, simple terms is that the seller has a right to stop the goods from being delivered if the buyer has not paid, and that this right lasts until the buyer take possession of the goods or other legal condition occur. The seller must inform the carrier to stop the good until the buyer made the payment. So I hope this helped you understand the stoppage in transit concept. Right, so if you really think this video was useful, please hit the like button. Now let's understand the unpaid seller and resale dynamic. So see, when a seller does not get paid, there are certain rights that comes into play. So first of all, unpaid seller, what are their rights? Have a look. So look at this particular table. So unpaid seller can retain possession of the goods under using lien or stop in transit, even if the good were subsold or placed to someone else. Second, however, if a good faith if a good faith buyer, means someone who bought the good in good faith, is involved, if the good faith buyer is involved, the seller right can be affected. Right, the key exception is when the buyer has paid or fulfilled all terms. This is the key exception. Now good faith buyer, see, a good faith buyer is someone who buy goods in good faith with no knowledge that the original seller has not been paid. So they are allowed to buy perishable goods, means goods that can spoil or get damaged. They receive a notice to the buyer informing that payment was not made and the good might be subject to the claim, or they can recover loss from the original seller if the goods are resold. However, buyer cannot make a profit when they resell the goods. They are simply expected to get their money back from the original seller. If they sell at a profit, the unpaid seller can't claim damage. Then original buyer, what are their responsibility? See, the original buyer means the one who purchased the good from the seller is personally responsible for paying the agreed price. The seller can take legal action if they don't receive payment. First of all, they can go for suit for price, asking the buyer to pay the original price, charging for any delay, that is called interest, damage if the seller has suffered loss due to the non-payment, and repudiation, means cancelling the contract. So to summarize this fact is that unpaid seller can hold the good until the payment is made, but this is subject to certain condition. I told you right, like good faith plus consideration buyer. So I told you the condition is that, what are the condition? That if good faith buyer is involved, the seller right can be affected. Right, so this is one condition. And the second point we discussed is that a good faith buyer can buy the goods but only get a refund, not profit, if the goods are resold. Right, so good faith buyer, they can partnership act. So at the center of every partnership lies an agreement. What agreement? किसी भी partnership के center में agreement lie करता है. What is an agreement? So agreement is a contractual relationship between two or more person. एक तरह का कॉन्ट्रैक्चुअल रिलेशनशिप होता है दो या दो से ज़्यादा पर्सन के बीच में, इट इज़ इंपॉर्टेंट टू नोट दैट दिस रिलेशनशिप मस्ट अराइज फ्रॉम अ कॉन्ट्रैक्ट, नॉट फ्रॉम स्टेटस और इनहेरिटेंस। ये बहुत ज़रूरी है कि ये जो रिलेशनशिप है वो किसी कॉन्ट्रैक्ट से अराइज हो, ना कि किसी स्टेटस से और ना ही इनहेरिटेंस से, राइट। कहाँ से अराइज हो? कॉन्ट्रैक्ट से अराइज हो। एंड द एग्रीमेंट कैन बी एक्सप्रेस्ड और एग्रीमेंट कैन बी इम्प्लाइड। So this is the very important point, that at the heart of, at the center of every partnership lie an agreement, which is a kind of contractual relationship between two or more person, right? And this relationship must arise from a contract, not from a status, not from inheritance. This is the first point. Now have a look at the number of person. So number of person involved. A partnership must have a minimum of 2 and maximum of 100 person. As per the section 464 of the Companies Act, remember it. मिनिमम कितने होने चाहिए? 2 लोग होने चाहिए। मैक्सिमम कितने होने चाहिए? 100 लोग होने चाहिए, एज पर द सेक्शन 464 ऑफ द कंपनीज एक्ट। ऑल्सो रिमेंबर, अ फर्म इज नॉट अ लीगल पर्सन बट अ कंपनी इज अ लीगल पर्सन। इफ द मेमोरेंडम ऑफ एसोसिएशन अलाउ इट, then firm is not a legal person but the company is a kind of legal person. If MOA allow, this is very very important. You know what is the meaning of MOA? MOA stand for memorandum of association. If the memorandum of association allow it, a firm is not a legal person but a company is a legal person. Minimum 2% in a partnership, maximum 100% in a partnership. Okay, now have a look at the business requirement, right? So चलिए हम बात करते हैं। अच्छा, उससे पहले मैं आपको पर्सन इन्वॉल्व के बारे में बता दूं। अच्छा, ये तो मैंने आपको बता ही दिया। हाँ, बिजनेस रिक्वायरमेंट की बात करते हैं। सो सी, द पार्टनरशिप मस्ट बी सेट अप फॉर कैरिंग ऑन अ लॉफुल बिजनेस। फर्स्ट पॉइंट, ट्रेड, लॉफुल बिजनेस, लॉफुल ट्रेड और लॉफुल प्रोफेशन। इट कांट बी फॉर इलीगल एक्टिविटी एज पर द सेक्शन 2 सब सेक्शन बी। इट मस्ट बी फॉर लॉफुल ट्रेड, ऑक्यूपेशन और प्रोफेशन, नॉट फॉर इलीगल एक्टिविटी। Then comes the profit motive. This is a key element. The purpose must be to earn profit and those profits must be shared among the partner. So this is the main purpose, to earn profit and sharing the profit among the partner. Lastly, the nature of the relationship is contractual nature. That means all conditions laid down by a valid contract must be followed. Means adherence to the valid contract condition must be followed. That is called contractual nature. So this is all about the Partnership Act, section 4 and 5 of the Indian Partnership Act. Every aspect we have covered. Now have a look on the limited liability partnership, which we call LLP. So the first point we have is called legal entity. So an LLP is its own separate legal entity. That means it continue to exist even if partner change. This is called perpetual succession. मतलब ये हुआ कि इसका अपना एक लीगल आइडेंटिटी होता है कि ये एग्जिस्ट तब तक रहेगा, मान लीजिए कि पार्टनर बदल भी क्यों ना जाए, पार्टनर चेंज भी क्यों ना हो जाए, फिर भी ये एग्जिस्ट करता है। दैट इज़ वाई इट इज़ कॉल्ड परपेचुअल सक्सेशन। सेकेंड पॉइंट, लिमिटेड लायबिलिटी। ईच पार्टनर रिस्क इज लिमिटेड टू द अमाउंट दे हैव एग्रीड टू कंट्रीब्यूट। प्रत्येक पार्टनर ने बोला है कि चलो हम इतना कंट्रीब्यूट करेंगे, हम इतना कंट्रीब्यूट करेंगे, तो उनका जो रिस्क है वहाँ तक लिमिटेड है। एवरी पार्टनर रिस्क इज लिमिटेड टू द अमाउंट दे हैव एग्रीड टू कंट्रीब्यूट, नो पर्सनल लॉस बियॉन्ड दैट। ठीक है, इसको बोलते हैं लिमिटेड लायबिलिटी। पहला पॉइंट मैंने बताया लीगल एंटिटी, यानी सेपरेट लीगल एंटिटी होता है एलएलपी का। इट कंटिन्यू टू एग्जिस्ट एवन इफ द पार्टनर चेंज, राइट। लेकिन पार्टनरशिप डिजॉल्व हो जाता है, लेकिन यहाँ पे ऐसा नहीं होता है। अच्छा, उसके बाद है लिमिटेड लायबिलिटी। सो ईच पार्टनर रिस्क इज लिमिटेड टू द अमाउंट दे हैव एग्रीड टू कंट्रीब्यूट, नो जॉइंट लायबिलिटी, वेरी वेरी इंपॉर्टेंट। वन पार्टनर मिस्टेक और मिसकंडक्ट वॉन्ट अफेक्ट द अदर, एवरीवन इज प्रोटेक्टेड इंडिविजुअली। यदि कोई पार्टनर गलती कर देता है या कोई मान लीजिए मिसकंडक्ट होता है तो दूसरे को कोई फर्क नहीं पड़ेगा, एवरीवन इज प्रोटेक्टेड इंडिविजुअली। एजेंसी प्रिंसिपल, a partner represent only the LLP, not the other partner. So this keep liability and responsibility clearly separated. इसको बोलते हैं एजेंसी प्रिंसिपल, कि एक पार्टनर जो है वो केवल LLP को रिप्रेजेंट कर रहा है, ना कि दूसरे पार्टनर को। इससे क्या होता है कि लायबिलिटीज और रिस्पॉन्सिबिलिटी क्लियरली सेपरेट होते हैं। देन वी हैव गवर्नेंस, which means the rule of the LLP are based on the mutual agreement and the LLP Act. So it is governed by mutual agreement and the LLP Act, not on traditional partnership norm. Then we have the minimum partner. So you need at least 2 partner and 2 designated partner to get started. How many partner? 2 partner and 2 designated partner to get started. Then we have conversion flexibility, which means existing business like firm and company can be converted into LLP. यानी आपके पास जो एग्जिस्टिंग बिजनेस है उसको, जैसे मान लीजिए कोई फर्म है या कंपनी है, उसको आप एलएलपी में कन्वर्ट कर सकते हैं। इन्वेस्टिगेशन, दैट इज़ कॉल्ड गवर्नमेंट ओवरसाइट। सो द सेंट्रल गवर्नमेंट कैन स्टेप इन एंड इन्वेस्टिगेट इफ नीडेड। सेंट्रल गवर्नमेंट सामने आके इन्वेस्टिगेट कर सकती है यदि ज़रूरत हो तो। देन वी हैव वाइंडिंग अप, एंड LLP एक्ट LLP can be shut down voluntarily or by the order of NCLT. तो हम LLP को या तो वॉलेंट्री शट डाउन कर लें या NCLT के ऑर्डर से शट डाउन कर लें. एंड लास्टली, द इंडियन पार्टनरशिप एक्ट डज नॉट अप्लाई टू LLP अनलेस स्पेसिफिकली मैंशनड. Very very important. Indian Partnership Act will not apply to the LLP, right? So what are the key points which we have just discussed? First of all, legal entity, separate legal entity, then limited liability, no joint liability, agency, governance, right? LLP Act is there, minimum partner. Do you know DPIN is issued, designated partner identification number, to each LLP member, and conversion, investigation, winding up, and Indian Partnership Act. These are the very important aspect. Now have a look at the foundation of partnership agency. Have a look at it. So you know, in a partnership, every partner have some power by default, right? Every partner have some power by default. Now friends, let's understand the foundation of partnership agency. In this particular diagram, everything will be clear. Partnership involve not only partner working together but also their role as agent in their firm. यानी पार्टनरशिप में केवल ऐसा नहीं है कि खाली पार्टनर आपस में एक साथ काम कर रहे हैं, उनका ये भी इंपॉर्टेंट है कि उनका फर्म में एजेंट के रूप में कैसा रोल है. तो लेट्स लुक एट द की एस्पेक्ट दैट डिफाइन पार्टनरशिप एजेंसी. फर्स्ट ऑफ ऑल वी हैव बाइंडिंग रूल. व्हाट इज द मीनिंग ऑफ बाइंडिंग रूल? बाइंडिंग रूल का मीनिंग क्या होता है? एनी एक्शन टेकन बाय अ पार्टनर मस्ट डिमॉन्स्ट्रेट द इंटेंट टू बाइंड द फर्म. This means the action should either be explicitly stated or implied through the firm name or business activity. तो what is the meaning of binding rule? इसका मतलब ये होता है कि कोई भी एक्शन जो पार्टनर लेंगे, राइट, वो इंटेंट को डिस्क्राइब करेगा, वो डिमॉन्स्ट्रेट करेगा क्या इंटेंट है. दिस मीन्स द एक्शन शुड आइदर बी एक्सप्लिसिटली स्टेटेड, या तो आप उसके एक्सप्लिसिटली स्टेट कर दीजिए या फर्म के नाम पे या बिजनेस एक्टिविटी पे इम्प्लाइड किया जाएगा. सो एक्शन मस्ट बी डिमॉन्स्ट्रेटेड. दिस इज कॉल्ड बाइंडिंग रूल. देन वी हैव डुअल रोल. So as a partner has plays a dual role. So कौन सा dual role होता है? It plays the role as a principal, which means representing their own interest, and it plays the role as an agent, which means represent the firm interest in its business dealing. So dual role. What is the meaning of dual role? It acts like a principal. The partner act like a principal, which represent their own interest, and it also act like an agent, which represent the firm interest in its business dealing. So that is called the dual role. Now have a look on the limit. Right, so binding role I have told you, dual role I have told you. Have a look on the limit. See, the implied authority of a partner is limited to the regular business activity of the firm. Right, this means that a partner cannot make decision beyond the usual scope of the business. यानी दोस्तों सिंपल सी बात है कि एक पार्टनर जो है अपने बिजनेस के स्कोप से बाहर डिसीजन नहीं ले सकता. तो वही होता है, implied authority does not extend beyond the firm regular business activity. Now have a look on the, so limits we have discussed. Have a look on the agency scope. On the right hand side you can see agency scope. See, a firm is only liable for action that are within the firm ordinary business operation. If a partner goes outside this scope, the firm is not responsible for their action. देखिए समझिए बात को, क्या कर रहा है कि जो एक्शन जो है, मान लीजिए पार्टनर ने कोई एक्शन लिया, तो फर्म लायबल होगा उस एक्शन के लिए तभी जब वो जो एक्शन लिया गया है वो बिजनेस के ऑपरेशन के स्कोप के अंदर है. यदि वो एक्शन स्कोप के बाहर है तो फर्म रिस्पॉन्सिबल नहीं होगा उनके एक्शन के लिए. So main thing is that if a partner take any action that goes beyond the scope of the business operation of the firm, then in that case firm will not be responsible for their action. Now have a look on the authority types. So two types of authority are there. Express authority, which means it is explicitly given, clearly stated, and then we have implied authority. Implied authority means it is inferred based on the firm business practice and how things have been done in the past. That is called implied authority. So two kinds of authority are there. Express authority means something that is given explicitly and clearly stated, that's called explicit authority or express authority. And implied authority means it is inferred based on the firm business practice and how things have done in the past. If you look at the personal act, if a partner make a contract in their own name, it become a personal responsibility. मान लीजिए कोई पार्टनर है, वो एक कॉन्ट्रैक्ट कर रहा है अपने नाम पे, तो ये पर्सनल रिस्पॉन्सिबिलिटी हो जाता है एंड फर्म इज नॉट रिस्पॉन्सिबल फॉर दोज एक्शन. So what we learned from this discussion is that So what we have discussed is the partnership agency. So in a partnership, each partner has the power to act on the behalf of the firm, but this power is limited to the firm usual business activity. यानी जितने भी पार्टनर होते हैं वो फर्म के बिहाफ में काम कर सकते हैं, राइट, लेकिन ये जो पावर है ना वो फर्म के बिजनेस एक्टिविटी के अंदर होना चाहिए. देयर एक्शन वेदर इम्प्लाइड और एक्सप्लिसिट कैन हैव पर्सनल एंड बिजनेस कॉन्सिक्वेंसेज. यस, उनका जो एक्शन है इसका पर्सनल या बिजनेस कॉन्सिक्वेंस हो सकता है. दैट इज द मेन पॉइंट. नाउ हैव अ लुक एट द इम्प्लाइड अथॉरिटी इन द इंडियन पार्टनरशिप एक्ट. So what is the meaning of this implied authority? Let's make it clear. So in a partnership, you know, every partner has some power by default. ये एक पार्टनरशिप में जितने भी पार्टनर होते हैं सभी के पास एक पावर होता है बाय डिफ़ॉल्ट, और उसी को हम लोग बोलते हैं इम्प्लाइड अथॉरिटी. लेट्स फर्स्ट लुक एट व्हाट पार्टनर कैन डू विदाउट आस्किंग फॉर एक्स्ट्रा परमिशन. सो पार्टनर क्या कर सकते हैं बिना एक्स्ट्रा परमिशन आस्क किए. सो दे कैन बाय और सेल गुड फॉर द बिजनेस, दे कैन रिसीव पेमेंट और गिफ्ट रिसिप्ट, they can settle business account, they can hire staff or borrow money, they can receive loan or they can credit, they can sign or endorse negotiable instrument like check, they can pledge firm good as security, they can even hire a lawyer for legal defense. So all of these are allowed as a part of running the firm regular business. So these are included. But what thing they can't do? Right, but some activity need a special approval from all partner. So let's look at these are not covered under the implied authority. So these things which we have discussed in the left side, they are covered under the implied authority. But there are something that need consent of all the partner. Right, so these are not covered by the implied authority, like taking dispute to arbitration, like opening a bank account in the firm name, like giving up or setting firm claim, like accepting legal liability, like transferring or acquiring immovable property, like suppose land, building, or adding a new partner on the behalf of firm. So they need express authority, they don't need implied authority. Is it clear now? अब देखिए कैच है यहाँ पे, देयर इज अ कैच. द कैच इज दैट इफ एनी पार्टनर डज समथिंग आउटसाइड देयर इम्प्लाइड अथॉरिटी इट इज़ नॉट वैलिड अनलेस ऑल पार्टनर रेटिफाई इट. मान लीजिए कोई पार्टनर ने कुछ ऐसा काम किया जो कि उनके इम्प्लाइड अथॉरिटी से बाहर है, तो वो तब तक वैलिड नहीं होगा जब तक बाकी सारे के सारे पार्टनर उसे रेटिफाई ना करें, मतलब वो एक्सेप्ट करें knowingly or legally. What is the meaning of ratification? Ratification just means acceptance knowingly and legally. So I hope it is clear what are the implied authority, what are the things which the partner can do without asking for permission, and what are the things for which they require permission from all the partner. Is it clear now? Because question is asked based on it. And friend, if you want such kind of PDF, you can enroll in our BRBL crash course program. In the description section of the video you will get link to the course, and you can just revise all the content very fastly using such kind of slides. Now then we have something called doctrine of holding out. So what is the meaning of doctrine of holding out? Let's make it clear. So friends, doctrine of holding out, let's understand it. Right, so first of all, this legal, it is under section number 28. This legal doctrine address the situation when a non-partner represent themselves as a partner or allow other to think they are the part of the partnership. मान लीजिए कि इसका मतलब ये होता है कि कोई नॉन पार्टनर है, वो अपने आप को पार्टनर के रूप में शो कर रहा है, दर्शा रहा है, या दूसरे को अलाउ कर रहा है ये सोचने के लिए कि वो भी पार्टनरशिप का पार्ट है. लेट्स डाइव इनटू द की पॉइंट. फर्स्ट ऑफ ऑल, डॉक्ट्राइन ऑफ होल्डिंग आउट. इफ अ नॉन पार्टनर प्रेजेंट देमसेल्फ एज अ पार्टनर और अलाउ समवन एल्स टू डू सो, दे विल बी ट्रीटेड एज अ पार्टनर लीगली. सो नॉन पार्टनर यदि मान लीजिए कि वो अपने आप को पार्टनर के रूप में दिखा रहा है या किसी और को वो दिखा रहा है, तो उसको पार्टनर ट्रीट किया जाएगा लीगली. दिस इज नोन एज होल्डिंग आउट बिकॉज दे आर एसेंशियली शोइंग देमसेल्फ एज अ पार्टनर टू द अदर. दैट इज़ वाई इट इज़ कॉल्ड होल्डिंग आउट, क्योंकि वो अपने आप को पार्टनर के रूप में दिखा रहा है. अब इसकी लायबिलिटी क्या क्या होगी वो देखिए. द पर्सन हु इज होल्डिंग आउट विल बी पर्सनली लायबल फॉर द फर्म डेप्ट if credit is extended under the belief that they are a legitimate partner. So they have personal liability. अब मान लीजिए फर्म का कोई डेप्ट है, कोई उधार है, राइट, सो दैट पर्सन हु इज होल्डिंग आउट विल बी पर्सनली लायबल फॉर दैट फर्म डेप्ट इफ द क्रेडिट इज एक्सटेंडेड अंडर द बिलीव दैट दे आर लेजिटिमेट पार्टनर. मान लीजिए कि फर्म को उधार दिया गया, क्रेडिट दिया गया, ठीक है, ये सोचते हुए कि जिसने क्रेडिट लिया है वो लेजिटिमेट पार्टनर है, तो वो लीगली लायबल होगा उसके लिए, वो डेप्ट के लिए लायबल होगा वो पार्टनर. समझ में है लायबिलिटी उसकी. नाउ फॉर्म, द रिप्रेजेंटेशन कैन बी मेड इन वेरियस वे, वेदर इट इज थ्रू स्पीकन वर्ड, written statement or even conduct, any form. exception. So there is an important exception that if a partner dies, their estate or their property left behind is not liable under the doctrine. So their personal liability does not transfer after death. See, until death their personal liability can be transferred, but after death their personal liability cannot be transferred. मतलब मान लीजिए कि पार्टनर का डेथ हो जाता है तो उनका जो एस्टेट है यानी जो प्रॉपर्टी है जो छोड़ के चले गए वो लाइबल नहीं होगा डॉक्ट्राइन के अंदर, राइट, ये ध्यान रखना है. देन वी हैव ट्रांसफरी राइट. So a person or entity that is transferring right from the partner has the right to receive the partner profit, share in the firm asset upon dissolution, verify the account and financial dealing of the partnership. So जो पर्सन या जो एंटिटी राइट को ट्रांसफ़र कर रहे हैं एक पार्टनर से, उनके पास क्या क्या राइट है कि वो प्रॉफिट रिसीव कर सकते हैं, शेयर रिसीव कर सकते हैं, अकाउंट को वेरीफाई कर सकते हैं, राइट. बट देयर आर लिमिट. No interference in the business decision or day-to-day operation. There will be no interference in the business decision. And the second point is no right to management or decision making. So what we learned from this discussion is that this is all about doctrine of holding out. The doctrine of holding out ensure that if someone present themselves as a partner, they are legally treated as such, with all the liability, with all the responsibility. But remember, once a partner passes away, their estate is exempted from this obligation. सो डॉक्ट्राइन ऑफ होल्डिंग आउट क्या बताता है कि यदि मान लीजिए कोई आदमी अपने आप को पार्टनर के रूप में दिखा रहा है तो वो लीगली माना जाएगा, सारा लायबिलिटी होगा, सारा रिस्पॉन्सिबिलिटी होगा, लेकिन जैसे उसकी डेथ हो जाती है तो उसका जो एस्टेट है वो इन सभी ऑब्लिगेशन से एग्जेम्प्टेड हो जाता है. दैट इज़ कॉल्ड डॉक्ट्राइन ऑफ होल्डिंग आउट. नाउ हैव अ लुक एट द सेक्शन नंबर 30. Section number 30 is all about minor as a partner. Very very important aspect. We are talking about minor as a partner. So let's start section number 30. So the first question is, can minor be a partner? See, under section 30 of the Indian Partnership Act, a minor cannot be a full partner, but they can be admitted to the benefit of an existing partnership. So they cannot be a full partner. वो full partner नहीं हो सकता, लेकिन उसे existing partnership के benefit के लिए तो admit किया ही जा सकता है. अब एक पॉइंट है एडमिशन टू बेनिफिट. सी, अ माइनर कैन एंजॉय प्रॉफिट एंड बेनिफिट फ्रॉम द फर्म बट विदाउट बियरिंग द फुल रिस्पॉन्सिबिलिटी ऑफ अ रेगुलर पार्टनर. तो इसमें क्या है, एडमिशन टू बेनिफिट का मतलब क्या है कि कोई माइनर यदि है वो प्रॉफिट और बेनिफिट एंजॉय कर सकता है फर्म से बट विदाउट बियरिंग द फुल रिस्पॉन्सिबिलिटी. व्हाट आर द राइट ही हैव? शेयर इन द फर्म प्रॉफिट, राइट टू एक्सेस एंड इंस्पेक्ट फर्म अकाउंट एंड शेयर इन द फर्म प्रॉपर्टी. दिस आर द राइट ही हैव. यानी फर्म के प्रॉफिट में शेयर ले सकता है, वो एक फर्म के अकाउंट को इंस्पेक्ट कर सकता है, एक्सेस कर सकता है और फर्म के प्रॉपर्टी में भी शेयर ले सकता है, राइट. सो व्हाट आई टोल्ड यू दैट a minor cannot be a full partner but can be admitted to the benefit of an existing partner. So he has the right, but there are some liability also. The liability of minor is limited only to their share in the firm. They are not personally liable even if firm incur debt or loss. Personal liability कभी नहीं होती है माइनर की, जितना शेयर उतना ही लिमिटेड है इसका. Suit, a minor cannot sue the firm for their share unless they decide to separate from the partnership. And then we have firm dissolution. If a minor is a part of the firm, other partner can still dissolve it just like any other firm. Attaining majority. So when the minor turn 18, they have to decide within 6 months whether to become a full partner or not. They must give a public notice of their decision. मतलब कि 18 साल होने के बाद उन्हें डिसाइड करना है कि वो पार्टनर फुल पार्टनर होना चाहते हैं या नहीं होना चाहते हैं, और इसके लिए उन्हें पब्लिक डिसीजन देना पड़ेगा अगले 6 महीने में. अब मान लीजिए कि पार्टनर होना चाहते हैं, सो दे विल नाउ बी लाइबल फॉर ऑल द फर्म एक्ट फ्रॉम द डेट दे हैव एडमिटेड टू द बेनिफिट एज अ माइनर, राइट. सो नॉट फ्रॉम देयर 18th बर्थडे, राइट. सो दे विल बी लाइबल फॉर ऑल द फर्म एक्ट. मतलब कि जिस दिन से वो माइनर भी थे और पार्टनरशिप लिए थे उस दिन से जितने भी बेनिफिट है सबके लिए वो लाइबल हो जाएंगे, सब एक्ट के लिए लाइबल हो जाएंगे. एंड सपोज दे डोंट बिकम अ पार्टनर, सो दे कंटिन्यू टू एंजॉय द बेनिफिट विदाउट एनी लाइबिलिटी एंड आर नो लॉन्गर कंसिडर अ पार्टनर वंस दे ऑप्ट आउट, right. So that is the point. So what is the main thing that we learned from this discussion is that, right, the main thing is that admission to benefit, they can admit to the benefit without full partner status. They have the right, they include sharing their profit, property and access to the account. Liability they have suit, but suit they cannot do, right. Firm dissolution, so other partner can dissolve the firm, no issue. And once they attain majority, they have to declare within 6 months whether they want to be full partner or not. And 2 conditions I told you. Now have a look at the partnership dissolution process. How does the partnership dissolution actually happen? तो कब और कैसे होता है पार्टनरशिप की डिसॉल्यूशन? तो कुछ बेसिक कंडीशन, देयर आर सम बेसिक कंडीशन अंडर विच पार्टनरशिप फंड को बंद किया जाता है. डिसॉल्यूशन मतलब यही होता है ना, बंद. सो लेट्स स्टार्ट विद सेक्शन नंबर 40. सेक्शन नंबर 40 सेज दैट जब सारे पार्टनर म्यूचुअल कंसेंट से एग्री हो जाए, व्हेन ऑल द पार्टनर एग्री बाय म्यूचुअल कंसेंट देन इट इज डिसॉल्व, या फर्म डिसॉल्व करना हो एज पर कॉन्ट्रैक्ट टर्म, कॉन्ट्रैक्ट में लिखा गया है कि फर्म को डिसॉल्व करना है तो फिर कर दीजिए ना. इफ इट इज रिटन इन द कॉन्ट्रैक्ट दैट फर्म हैज टू बी डिसॉल्व देन प्लीज डिसॉल्व इट, दैट इज सेक्शन नंबर 40. देन कम सेक्शन 41 विच मीन्स कंपल्सरी डिसॉल्यूशन. कुछ सिचुएशन में फर्म को कंपल्सरी बंद करना पड़ता है, जैसे इंसॉल्वेंसी हो जाए सारे पार्टनर का, या अनलॉफुल बिजनेस, सपोज ऑल द पार्टनर बिकम इंसॉल्वेंट और दे अंडरगो सम काइंड ऑफ अनलॉफुल बिजनेस, इन सच केस firm has to be compulsory dissolve. Then comes section number 42. So there we have dissolution by contingency. सम इवेंट, कुछ इवेंट ऐसे होते हैं जिसमें डिसॉल्यूशन ऑटोमेटिक हो जाता है, जैसे कि फिक्स टर्म का ख़त्म होना, टास्क कंप्लीट हो जाना, देन पार्टनर की डेथ होना, या पार्टनर का इंसॉल्वेंट होना, या अनसाउंड माइंड होना. सो देर आर सम केसेस, देर आर सम इवेंट अंडर विच डिसॉल्यूशन ऑटोमेटिकली, लाइक फिक्स टर्म, एक्सपायरी ऑफ फिक्स टर्म, completion of task, death of partner, and partner insolvent or unsound mind, right? In this case firm get dissolved by contingency, fixed term, a task completion, etc etc. Then comes dissolution by court. जब सीरियस इशू हो जाए तो कोर्ट इंटरवीन करता है, जैसे मान लीजिए कि पार्टनर इनकेपेबल हो ड्यूटी निभाने में, मिसकंडक्ट हो जाए, फ्रॉड हो जाए, ब्रीच ऑफ एग्रीमेंट हो जाए, पार्टनर ने अपना इंटरेस्ट ट्रांसफ़र कर दिया हो, बिजनेस हो रहा हो लेकिन कंटिन्यूस लॉस में हो, और कोई जस्ट और इक्विटेबल रीज़न हो. सो बिकॉज ऑफ दिस रीजन, इनकेपेबल ऑफ ड्यूटी, अनसाउंड माइंड, मिसकंडक्ट, ब्रीच ऑफ एग्रीमेंट, ट्रांसफर ऑफ इंटरेस्ट. सो दिस इज सेक्शन नंबर 44. So you know every dissolution has a reason, when sometimes mutual, sometimes legal. That's why partnership is not all about starting, right? It should be about the closing it correctly. पार्टनरशिप केवल शुरुआत करने का नहीं है, सही से बंद करना भी जरूरी होता है, समझे दोस्तों. तो देखिए आप बुक पढ़ेंगे ना तो लाइन बाय लाइन चीज़ें मिलेंगी, और यहाँ पे आपको पिन पॉइंटेड कंटेंट मिलेगी, जिसके माध्यम से आपके दिमाग में चीज़ें छप जाएंगी और एग्जामिनेशन में आप उसका लाभ उठा पाएंगे. नाउ हैव अ लुक एट द नेक्स्ट स्लाइड, दैट इज कॉल्ड रजिस्ट्रेशन एंड लीगल इम्प्लीकेशन ऑफ पार्टनर. सो रजिस्ट्रेशन एंड पार्टनरशिप फर्म, राइट, इज इट नेसेसरी और नॉट, राइट? सो आई टोल्ड यू, लेट्स टॉक अबाउट द रजिस्ट्रेशन एंड क्या रजिस्ट्रेशन और ज़रूरी है, राइट? रजिस्ट्रेशन ऑफ पार्टनरशिप फर्म जरूरी है या ऑप्शनल है? तो सबसे पहले कि रजिस्ट्रेशन मैंडेटरी नहीं है, इट इज़ नॉट मैंडेटरी, इट इज़ डीड ऑप्शनल, क्लियरली रिटन. लॉ सेज दैट पार्टनरशिप रजिस्टर करवाना मैंडेटरी नहीं है, इट इज़ नॉट मैंडेटरी टू रजिस्टर पार्टनरशिप. लेकिन अगर रजिस्टर नहीं किए तो लीगल एक्शन में दिक्कत होगी. इफ़ यू डोंट रजिस्टर यू विल फेस प्रॉब्लम इन द लीगल एक्शन, राइट? सो नाउ द क्वेश्चन इज, इफ़ द फर्म इज़ नॉट रजिस्टर्ड, राइट, अगर फर्म रजिस्टर्ड नहीं है तो क्या नहीं कर सकते? So what you cannot do for unregistered firm? So first of all, partner versus other firm partner, right? So the first thing is that you can see it here, no suit is permitted. You know that suit file नहीं कर सकते. Firm versus third partner, legal action नहीं ले सकते. Contract based set off, क्लेम भी रिजेक्ट हो जाता है. तो ये सब प्रॉब्लम सेक्शन 69 के अंदर आती है. देन इफ़ यू लुक एट द अनरजिस्टर्ड फर्म स्टेटस, सो दे गेट द लिमिटेड राइट, दे डोंट गेट द लीगल प्रोटेक्शन. दैट्स वाई मोस्ट फर्म रजिस्टर हो जाती हैं ताकि फ्यूचर लीगल हर्डल्स को अवॉइड करें. नाउ डीड ऑप्शनल है, डीड इज़ ऑप्शनल, लेकिन डीड लिखना ऑप्शनल है, लेकिन हेल्पफुल होती है फॉर क्लैरिटी. अब कहाँ पे एप्लीकेबल नहीं है, इन विच केस इट इज़ नॉट एप्लीकेबल? सो रिमेंबर, इट इज़ नॉट एप्लीकेबल टू some area, right? जो कि सेक्शन की फीचर ऑफ कंपनी. You know, when a company is created, it become a separate legal entity. So we are discussing each and every part. It become a separate legal entity whenever a company is created, just like a person, but artificial. It can own property, it can sign contract, it can even go to the court. Now the first point we have is the independent corporate personality. So once registered, you know, once a company is registered, a company is separate from its owner. Separate legal entity post incorporation, not like partnership. In partnership, you know, there was no separate legal entity, but in the case of company, it is a separate legal entity, right? Company has its own name, company has its own right, company has its responsibility. It is not mixed with the founder. Now, one famous case is Salomon versus Salomon is confirmed in this law, right? They took debenture, they took share, and company get liquidated, credit claimed, and House of Lord say that company is a separate entity. So that is the point. Now have a look at the registration part. So you know every company must be registered under the Companies Act 2013. Once registered, it is official. No need to re-register even if the law changes later. And the last point is artificial legal person. A company is not a human, but the law treat it like a human. It can own property, it can borrow money, it can sue, it can be sued. although it does not breathe or walk, it has legal right just like a citizen. You can see it has legal right, contract, on property, constitutional, citizen, right? It has nationality and domicile. Now have a look at the difference between the company and partnership. So company versus partnership, let's break it down. Choosing between a company and partnership, here is how they differ in the key area. First of all, let's start with the liability. So in a company, member usually have limited liability, means their personal assets are safe. But in a partnership, liability is unlimited, meaning partner are personally responsible. Second point is registration. So company must be registered under the Companies Act, but partnership don't always need registration, but it is recommended. Then we have the members and partner. A public company needs 7 member to unlimited member. A private company minimum need 2 member and maximum 200 member. A partnership must have minimum 2 with a maximum of 50 partner. I think 100 partner given, right? Now legal status, have a look at the legal status here. So that a company is a separate legal person, it exists independently, but a partnership have no separate legal entity. So a partnership don't have any legal entity, right? So this is very important thing. Then we have ownership of property. So in company, property is owned by the company itself, but in the case of partnership, property is owned jointly by the partner. Then we have management. So company are run by a board of director, while partnership are managed by the active partner, right? Then we have the perpetual existence. So a company continue to exist even if member leave, but a partnership may get dissolved when a partner leave or a partner die. Then we have contract. So a company can enter into contract in its own name. In a partnership, contract are in the name of the partner. So a company can enter into contract in its own name, but in a partnership, contract are in name of the partner. So basically this entire comparison help you understand, right, the best way to understand the difference between company and partnership. And at the time of examination, if you see this particular slide, you will be able to recall every fact regarding the difference between company and partnership. That's why I tell you now, such kind of PDF is very useful for subject like BRBL, which is completely theoretical. And if you want it, you can enroll in our BRBL crash course program. The link is provided in the description section. Now let's have a look at MOA versus AOA. What is the difference? So let's break down Memorandum of Understanding and Article of Understanding. First of all, nature. Here on the right hand side you can see MOA is like the company birth certificate, right? It shows its goal, it shows its limit, it shows the legal boundary. So that is why it is called like company birth certificate, goal, limit, legal boundary. But AOA is the rule book. It controls how the company is run from inside, right? So that is the point. Rule book, AOA, MOA is like the birth certificate. Then we have the contravention. Try to understand. If the company does something beyond MOA, it is invalid and it can't be fixed. But if you break the AOA rule, it is not that serious. Shareholder can approve and fix it. But if the company break MOA, it is ultra vires. It is invalid. It can't be fixed. Then we have alteration. If you changing the MOA needs a special process, which means resolution and government approval. If you want to change the MOA, it need a special process, which means resolution and government approval. But changing AOA is easier. Just pass a special resolution, that's it. Now have a look at the dominance. So MOA is supreme. It is set the foundation, but AOA comes after. It works within the limit set by MOA. So friends, I hope this diagram make it easy to understand the difference between MOA and AOA. Please hit the like button if you really think that it was easy to understand. Now let's decode a legal term that often confuse many, that is called ultra vires. First of all, let's talk about the meaning on the right hand side. See, ultra vires means beyond the power of the company. Action that are outside what is written in the company memorandum of association. MOA. So if you are taking any action which is beyond, which is outside what is written in the company MOA, it is called ultra vires, right? Means beyond the power of the company. If something is done within the power mentioned, it is called intra vires. So two things are there. Ultra vires means beyond the power of the company, and intra vires means something within the power mentioned. So this is the difference between ultra vires and intra vires. Now have a look at the rule, right? So here is the rule. The very important rule says that if the company act beyond its MOA, these acts are void, means they have no legal value. This means the company can't be sued on such act, and company can't enforce them either. So if any company act beyond its MOA, these acts are void, they have no legal value, the company can't be sued on such act, and company can't enforce them either. And then principle. What is the meaning of principle? MOA gives the company positive authority, means what it can do, plus negative restriction, what it cannot do. So important point is that terms in MOA are interpreted narrowly, not broadly. There was a landmark case, right? Remember, question is asked on the basis of case, Asbury Railway Co versus Rich, right? The company signed a contract to finance railway in Belgium, something not stated in MOA. The result, the contract was declared ultra vires and hence invalid. So remember, company can do what is clearly written in their MOA. Anything else, legally powerless. That is all ultra vires is all about. I hope it is clear your concept. Now, what is the effect of ultra vires action? So now that we know what ultra vires mean, let's see what happen when a company cross its legal limit. First of all, director liability. If the director approve an ultra vires payment or act, they can be personally liable. Directors is personally liable if they approve it, right? If there is a fraud, misapplication or misuse of fund, it may lead even to the criminal action. Then property purchase. Even if a purchase is ultra vires, the company still own the asset. Why? Because it represents capital and ownership stay valid. So in the case of property purchase, even if the purchase is ultra vire, the company still own the asset. This is very important because purchase, it represents capital and ownership stay valid. What about company borrowing? If company borrow for something that is not in MOA, the contract is not binding. But lender can still recover money from a specific asset if they can trace it. That is called doctrine of tracing. So if they can trace it, the lender, whoever had lended, they can recover money from a specific asset. What about recovery? If the service or money were given under an ultra vires agreement, company can recover what it gave. So suppose a company gave some kind of service or some kind of money, and they under the ultra vires agreement, means voidable agreement. So company can recover that money. But if service were received, the other party can't demand payment. This is very important thing. If service were received, then other party cannot depend. For example, property wrongly transferred may still be traced and recovered, right? Now, ultra vires contract. See, company cannot ratify ultra vires contract. No one can enforce such contract against the company. So these are the very important point. Means what are the power of the company? Means what company can do? What are the effect? So director liability is limited because director can be sued for if he take any decision. Then property purchase, it is valid. See, you can see I have given cross also and tick mark also, right? Lender can recover asset. Lending ultra vires, borrower can recover. Service rendered extra vires, they can claim charges, right? So these are the important parts. Now have a look at the next one, that is called doctrine of indoor management. So what it is all about? Imagine you are dealing with a company from the outside. Should you worry about all the internal paperwork and approval? Luckily, you don't have to. That is the power of doctrine of doctrine of indoor management. So you are dealing with the company from the outside. So should you worry about all the internal paperwork and approval? No. So what does it mean? Let's understand. So this rule protect outsider, right? So basically, if we talk about the rule, it protect outsider. As you can see, it protect outsider, like creditor, supplier, dealing with the company. If your contract matches with what is written in the company MOA and AOA, you don't need to check if all internal procedures were followed or not, right? So if your contract matches with what is written in MOA and AOA, you don't need to check. So in simple term, right? In simple term, these are the case, right? So in simple term, we can say that if you assume the company has done its homework, passed resolution, got approval, it look right from outside, you are safe. But there are some exception. What are exception? Let's see. Right, if you know that there is something wrong internally, no protection is there. If the person act beyond their visible power, the deal is not valid, and no protection is given if something too unusual to be real. You should have checked. One key case is is the Lakshmi Ratan versus JK Jute Mill, 1957. Director borrowed money without showing the board resolution, but since MOA allowed it, the outsider were protected, right? So the bottom line is that this doctrine, right? So this doctrine ensure fairness. You trust the company on the outside and you don't suffer just because someone inside skipped a step, right? That is all about it. Now have a look at the prospectus. Understanding prospectus made it simple, right? So first of all, a prospectus is just like formal invitation. It is a document that a company issue when it want to raise money from the public by selling share. So suppose some company want to raise money from the public, so they issue the share, they issue the security, and this document is called prospectus. It is like formal invitation. So what does the law say? Any notice, any ad, any circular asking the public to buy share, that is called prospectus, right? Notice, circular, ad, anything. Now have a look at the types of prospectus. One is called red herring prospectus, RHP. It is a draft prospectus with basic information, right? First of all, but no final price on the number of share. Number of share is not declared. It is filed 3 days before the issue. It must meet full SEBI and ROC guideline, and it in any changes, if any, it must be highlighted, right? Variations should be highlighted, and it is used before the final offer. These are the important parts. Now, second type of prospectus we have is called self prospectus. What does it mean? These allow company to issue security in multiple round over the time. You can see multiple issue over the time. Second point is filed once and reused. So it can be reused, right? It saves time and cost. Only public company can use it. And then if you look at some key points that public company, so public company can issue a prospectus, private company cannot invite the public for fund. And capital solicitation tool, you can think of a prospectus as a tool to collect money from the public. So the next time you hear prospectus, remember it is the company pitch to the public for investment, like a formal brochure before buying into the business. So that is prospectus all about, right? Now have a look at the director requirement in India. Running a company in India come with clear rules about who can be director. Here is everything you need to know in the simplest way. First of all, independent director. Every aspect we have covered. See, for listed public company, right, we will talk about later. So it must be independent director must be an employee or must not be an employee, must not be an owner, must not be a nominee, right? Very, very important. Second point, he should bring expertise, knowledge and experience. He cannot be a promoter or related to a promoter. No big money dealing with the company in the last 2 financial years. They must stay neutral, right? Companies must have at least 1/3 of their board as independent director. This is very, very important, right? So 1/3 of the board should be independent director company. Now what about the resident director? At least one director must stay in India for 182 days or more in the previous calendar year. That is called resident year. At least one. Women director. Companies in certain prescribed category like listed company, right, must have at least one woman director. What about the maximum director? You can have maximum up to 15 director. If you want more, you have to pass a special resolution to go beyond 15. What about the minimum director? So if it is a public corporation, they need at least 3 director. Private corporation, they need at least 2 director. One person company need just one, because the name itself is one person company, right? So they are listed public corporation, minimum 1/3 is per independent director. So the central government can ask for more director in the same public company if it is needed. So this is all you need to know. Maximum director, how many can be there? Minimum director, how many can be there? Resident director, what are the condition of independent director? Every aspect we have covered in this particular slide, right? Now have a look at the independent director relative association, every aspect. Who can be an independent director? Let's talk about the restriction. So being an independent director means you should stay free from personal or business tie that may affect your decision making. So what does the law say? First of all, let's look at section number 149(6), that is self-relative. See, what does it say? That self-relative must not be a key managerial person. That is called KMP. What is KMP? KMP means key managerial person. Means self or relative must not be key managerial person or employee in the company or group in the last 3 financial year. First point. Second point, the relative working as employee is allowed but not in any other major role. Then partner or employee of the company audit or consulting firm he should not be, right? He should not be the partner or employee of the company audit or consulting firm in the past 3 years. He should not be a consultant legal firm earning 10% or more of its income from the company. He should not be having more than 2% voting power in the company. He should not be a CEO, director of an NGO that get 25% or more of its fund from the company. So these are the things that a director cannot be, right? Or relative cannot be. Self or relative cannot be. And what is allowed? Let's see section number 149 subsection 6D. So resident are not allowed, are not eligible if they hold security or they hold interest in the company or its group beyond 50 lakh or less than 2% of the paid up capital. Second point, if they are indebted to the company or its group above the prescribed limit, so they are not allowed. Resident, we are talking about resident. If they have given or received guarantee for any loan from or to the company, if they have any financial relationship over 2% of the group turnover. In short, an independent director must truly be independent, no close tie, no financial base. Bias should be there. Now, have a look at the corporate governance framework. Very, very important. Corporate governance is all about ensuring that companies are run fairly and transparently. Let's see what power the board has and where are the restrictions. First of all, restricted board power. The first point is disposal of undertaking, which means the board can't just sell off major asset without approval. First point. Second point, debt remission to the director, which means giving debt forgiveness to the director is not allowed. Right, you can't give debt forgiveness to the director, no exception. Then we have borrowing money or raising capital. There are limit to how much the company can borrow and raise, and it must be done in responsible manner. Then we have compulsory, acquisition. The board cannot acquire non-trust security without strict approval. Charity contribution. If the company want to donate more than 50 lakh or 5% of the average net profit for the last 3 years, it need permission. So these are restrictions. What I told you, first of all, disposal of undertaking. They can't sell more major asset without approval. Debt remission to the director. Giving debt forgiveness to the director is not allowed. Then borrowing money or raising capital. There are limit to how much the company can borrow and raise. Compulsory acquisition. Board cannot acquire non-trust security without a strict approval. And they cannot give charity more than 50 lakh or 5% of the average net profit for the last 3 years. What about loan to the director? No direct loan. Company cannot give loan, guarantee or security to their director, whether directly or indirectly. Exception is there that loans are allowed. An LLP must have at least 2 designated partner. Out of these 2, one must live in India, and if the partner is a company, a nominee must be appointed to act on its behalf. So first of all, key point, remember, 2 designated partner. Out of these, one must live in India, and if the partner is a company, the nominee must be appointed to act on its behalf. Then we have the minimum partner. You need at least 2 partners to form an LLP, at least 2 partners. If only one remain for more than 6 months, they become personally liable for the firm obligation. At least 2 partners is required. If only one remain for more than 6 months, they become personally liable for the firm obligation. So 6 months. Personal liability after 6 months of carrying business alone, as per the section number 6. Minimum 2 partner and personal liability after 6 months. Then we have body corporate. What is body corporate? An LLP is a separate legal entity. That means it continue to exist even if the partner change. That is called perpetual succession. Perpetual succession means LLP is a separate legal entity. It continue to exist even if the partner change. Now what about the partners? See, individual or even company can be a partner in LLP. Individual or company can be partner in LLP. However, there are few restrictions. Like a person can't be a partner if they are insolvent, if they have unsound mind, if they are legally restricted from doing so. So individual or even company can be a partner, right? So this structure ensures that LLP are flexible yet legally sound, simple, efficient and modern. So at least 2 designated partner, one must be resident in India, and then minimum partner, at least 2 partner is required, and sole partner liability after 6 months of carrying business, and it is a separate legal entity. Perpetual succession, right? I told you that LLP is a separate legal entity. It continue to exist even if the partner change. Perpetual succession. And partner, individual or even company can be a partner in LLP, but some restrictions are there. Now have a look at the next slide, LLP partnership structure. So friends, let's look at how LLP partnership is structured and how partner work together. The first one is the eligibility. You can see. So only those involved in setting up the LLP or called incorporators can be a partner in the beginning. So what I am telling you, only those involved in setting up LLP, they are called incorporator. So incorporator can only be partner in the beginning, other can join later as per section 22. So who are incorporator? So those who are involved in setting up the LLP is called incorporator. Section number 22, please remember it. Then we have something called partner pre-incorporation agreement. Have a look at it. Just wait. Yes, here you can see pre-incorporation agreement. Try to understand. Before the LLP is officially registered, the partner may agree on some terms, and this agreement must be confirmed by all partners after the LLP is formed. So what I am telling you, that before LLP is registered, before the registration of LLP, partner may agree on some terms. There are some terms on which they may agree, and the agreement must be confirmed by all the partner after the LLP is formed. That is called ratified by all the partner post incorporation. So those agreement from on which before the registration of the LLP some terms were there, so agreement must be confirmed by all partners. Then we have LLP agreement. What is the meaning of LLP agreement? This is the most important document. It clearly defines how the LLP will be run, the role of each partner, how decision will be made. It is about LLP agreement. It is governed under section number 23. Then agreement change. Any update, any change to the LLP agreement must be filed with the registrar to keep things official and legal. And then we have first schedule provision. If there is no LLP agreement, don't worry. The law provide default rule. There is a default rule. These are called first schedule provision, which ensure that LLP still work smoothly. So what we learned, first of all, eligibility. I told you that only those incorporator who are involved in setting up the LLP can be partner in the beginning. Other can join up as per section 22. Pre-incorporation agreement means before the LLP is officially registered, the partner may agree on certain terms, and the agreement must be confirmed by all partners after the LLP is formed. Then we talked about LLP agreement. Most important document it is. It defines how the LLP will be run, the role of each partner, and how decision will be made, governed under section number 23. Remember it. Partner relationship. Then we have agreement change. Any change in the agreement, any update in the agreement must be filed with the registrar. And the first schedule is, suppose there is no agreement, no LLP agreement, don't worry. The law provide default rule, and these default rule are given in the first schedule provision. Now friends, have a look on the cessation of partnership. So what is the meaning of cessation of partnership? So cessation of partnership, have a look at it. So when a partner stop being a part of limited liability partnership, it is called cessation of partnership. What is the meaning of cessation? Suppose a partner, right, stop being a part of LLP. This is called cessation of partnership. Let's break it down. First of all, we have resignation. A partner can leave by giving a 30-day notice or through mutual agreement with other partner. So two way, either they give 30-day notice or they through the mutual agreement with other partner. These are two way of resignation. Then we have something called forced cessation. Sometimes a partner must leave due to death, insolvency, mental illness or court order. Section 24 subsection. Now friends, one more thing, obligation does not end. Even after leaving, right, even after leaving, the partner is still responsible for any earlier duties or any promise made within the firm. This is called obligation. Then we have entitlement. The former partner has right to get back their capital and share in profit after losses are adjusted. Then we have the no more management right. When a partner exits, they can't interfere in the management of the LLP anymore. So to summarize the cessation of partnership journey in the LLP, but the responsibility and right are carefully protected by the law. So just let me revise you once more. First of all, resignation. So basically resignation, they can leave by giving a 30-day notice, right? Second point is forced cessation, which means sometimes a partner may leave due to death, insolvency, mental illness. Then formal partner status, until proper leaving, until proper notice is given to the other partner, the person is still considered a partner. Obligation does not end. And entitlement, right? So they have the right to get back their capital, and they cannot interfere in management. So these are the important points. Now have a look at the conversion to the LLP, conversion to the limited liability partnership. Very, very important. So if you want to turn your business into LLP, let's see how easy it is. So you will get to know from this particular slide how easy it is to turn your firm into LLP. So first of all, you can convert different types of business entity into LLP. Let's see the path. First of all, firm to LLP. If you are running a traditional partnership firm, you can convert it under chapter 10, second schedule of the LLP Act. So firm to LLP can be converted under the chapter 10, second schedule of the LLP Act. Then private company to LLP. So if you own a private limited company, so conversion is possible under chapter 10, third schedule. And if it is unlisted company, so even unlisted company can become LLP by following chapter 10 fourth schedule. So firm can become LLP, private company can become LLP, and unlisted public company can become LLP, and there are different chapter, different schedule, and once the correct process and a schedule is followed, the conversion is complete. Now you are an LLP with limited liability and flexibility in operation. So this conversion brings more protection and professional structure to your business without losing control. Now have a look at LLP conversion and compliance. Very, very important. Let's understand what every limited liability partnership must follow after formation or conversion. First of all, we have is the registration. Let's look at the bottom. First of all, we have is the registration. So when an entity convert into LLP, it must register under section number 58. Right. So section 58 says that registrar may update the name, registrar update the detail in the official record. Right. So you can see registrar role is there. They register LLP if condition in the second, third and fourth schedule are met and a specific date LLP is registered, right? And then LLP must inform its old authority like registrar ROC within 15 days, right? So earlier it was a firm, obviously it will have registered. So that particular LLP, that particular firm which has converted to LLP, it must inform its old ROC within 15 days of registration. partner, shareholder bound by the relevant schedule. So this is about LLP registration. Then we have conversion effect. See, after conversion, the LLP legally replaces the old entity. So LLP legally exists, right? LLP legally replaces the old entity. All asset, all liability, all right, all obligation move to the LLP, and the old company or old firm is removed from the record. So this is called conversion effect. Once an LLP get converted, what happen? LLP legally replace the old entity. All asset, all right, all liability moves to the LLP, and the old company or firm is removed from the record. This is called conversion effect. Now annual filing, section number 34. LLP must file a statement of account and solvency every year. It must be filed within time or there will be penalty. That is called annual filing of penalty. A statement of account and solvency every year. It must be filed by LLP. It must be filed within 1 year. Very, very important time period. Within time, sorry, not 1 year, within time, or there will be penalty. Then we have audit standard. LLP must follow proper accounting and auditing standard. These are set by the government or NFRA under the law. Then we have the penalties. So as per the section number 35, any delay in filing the annual return after 1st April 2022 attract a fine. What is the fine? 100 rupees per day for LLP and designated partner, right? Same 100 rupees per day. Maximum it can go to 1 lakh for LLP, and for designated partner it can go to 50,000. So if you have no cap, more delay, more penalty. So basically, I hope that is why. Did you know that there are different types of mortgage? Let's break them down in the simple way. First of all, we have simple mortgage. What is simple mortgage? Simple. The borrower keeps the property, but if they fail to repay the loan, the lender can sell it. There is no change in possession, just a strong promise. So it is called simple mortgage. Again, I am repeating, the borrower keeps the property. Who keeps the property? Borrower. Borrower keeps the property, right? But if the borrower fail to repay the loan, if the borrower does not repay the loan, the lender can sell it. There is no change in possession, just a strong promise. Then we have mortgage by conditional sale. This one look like a sale, as the name itself suggests, sale. This one look like a sale, but with a catch. What is the catch? If the borrower repay, the sale is cancelled. If not, the lender may get full ownership. That is called sale. See, if you go through the book now, there is a hard term, there is a typical term which they have written, and I am trying to provide you the same content in the simplest way possible. Then we have something called, usufructuary mortgage, right? So here what happened, the lender get to use the property or earn income from it like rent until the loan is repaid. Lender, yes, whoever has lended, they get to use the property or earn income until the loan is repaid. It's like using the property instead of getting monthly payment. So you are using the property instead of getting the monthly payment. That is called usufructuary mortgage. Then we have something called English mortgage. What is English mortgage? It involves a full transfer of property to the lender, but with a fixed repayment date. So what happened in the case of English mortgage? Full transfer of property. As the name suggests, full transfer of property to the lender, right? But with a fixed repayment date. Once the borrower pays it back, the property is returned. That is called English mortgage. Again, I am repeating, full transfer of property to the lender, right, with a fixed repayment date. Once the borrower paid back, the property gets returned. That is called English mortgage. And what is equitable mortgage? There is no formal transfer. The borrower just give the lender their property document and promise to pay, usually done in certain town. So whether you are a student, home buyer, or just curious, understanding this type help you know your rights and risk in any property loan. So just let me recall, just me remind, simple mortgage, what I told you, what happened in the simple mortgage, the borrower keeps the property, but if they fail to repay the loan, the lender can sell it. Mortgage by conditional sale, it is just like a sale, but with a catch, if the borrower repay, the sale is cancelled. Usufructuary mortgage means, rent and rent will be collected by the lender, right? So that lender can get to use the property and earn income from it. Then we have English mortgage, right? Usufructuary, English mortgage is what is all about. Here full transfer of property to the lender, right? Full transfer of property to the lender, but with a fixed repayment date, right? Once the borrower pays it back, the property is returned. And equitable mortgage means no formal transfer is there. The borrower just give the lender their property document and promise to repay. So that is all about. Now friends, have a look at the next slide that we have. So the next slide is related to the transfer of actionable claim process. So let's get started. Let's understand what is this all about. So let's explore something that sound complex but plays a big role in legal and financial matter. That is called transfer of actionable claim. So first of all, you must know what is actionable claim. Actionable claim is basically a right to recover an unsecured debt, right? Suppose you have an unsecured debt, and you have given unsecured debt, and you want to recover it. So the right that you have is called actionable claim. That means there is no mortgage, there is no place, there is no hypothecation involved. You are claiming a benefit in something even if it is not physically in your hand. Again, I am repeating, what is actionable claim? It is basically a right to recover an unsecured debt. So bank has given unsecured debt, and bank has certain right to recover that. That is called actionable claim. This means there is no mortgage. You have not taken anything as security, neither mortgage, neither pledge, neither hypothecation, nothing. You are claiming a benefit in something, even if it is not physically in your hand, because you have not taken any security. And again, still you are claiming your, claiming a benefit in something. So this kind of claim must be recognized by a court to be valid. So here it is written, right? It should be recognized by the court to be valid, right? And it can apply to existing, future, accruing, or even conditional debt. So what are the main points? I told you unsecured debt, beneficial interest in the movable, not in possession, right? Recognized by court for relief, and debt type we have talked about. Now the question is, how is it transferred? Very important. Simple. The transfer needs to be in writing, signed by the person transferring the claim. So first of all, it should be written instrument, right? First point, it should be in the form of writing. And who should sign it? Transferor should sign it. Who is transferor here? So transfer is the person who is transferring the claim. So key points you must remember: it should be written instrument, it should be signed by the person transferring the claim, and no court registration is required. Here no court registration is needed. Even better, there is no need to inform the debtor. So no notice to the debtor required, no need to inform the debtor. Yes, you heard it right. The debtor does not need to know about the transfer, but if they pay the original creditor, which means the transferor, the payment is still valid. So question is, how is it transferred? Again, I am repeating, the transfer needs to be in writing, signed by the person transferring the claim. So whoever is transferring the claim, he will sign it. No court registration is required, and no need to inform to the debtor, whoever has taken the debt. So the debtor does not need to know about the transfer, but if they pay the original creditor, if they have paid the original creditor, then the payment is still valid. Now one more point is that the new holder of the claim has the full power to sue and recover the money, right? So this is the point. The debtor is not notified of the transfer, right? So one illustration is given in your book, as you can see, as the case of this illustrate the transfer claim. So imagine A owes money to B, right? A owes money to B, right? Now B transferred that claim to C. Now if A pays C, neither B nor C can claim again. Simple as that. Once paid, the claim end. That is the point. So A owes to B, and B transferred that claim to C, and A pays to C. Now neither B neither C can claim again. That is called illustration of transfer. That is what I told you now. Basically, once the debtor does not need to, but if the debtor pay the original creditor, the payment is still valid. That is what I told you. Now case 1, there are some case in the book, and case study are most frequently asked. Dena Bank versus Bhikhabhai Prabhudas Parekh. See what happened in this case. This case highlight that government due get top priority when it comes to payment. Very, very important. See, we don't have to go through the detail of the case study. In the book you will see detailed case study written. No, we have to understand what was the implication, what was the conclusion that we can draw from this case. See, this case highlight that government due get top priority when it comes to repayment, and this is called crown debt. So question may be asked, what is the meaning of crown debt? So crown debt means government dues get top priority. But remember, this priority only apply if a special legal provision exists. So the court studies law like sales tax, land revenue act, and even used precedent from both India and UK to make its decision. So Dena Bank versus Bhikhabhai Prabhudas Parekh, this case highlight that government dues get top priority when it comes to repayment, and this debt is called crown debt. So remember, this dues is called crown debt. So this priority only apply if a specific legal provision exists. You can see, if a specific legal provision exists, then only this priority will apply. And the court study law like sales tax and land revenue act, and even use precedent from both India and UK to make its decision. So who get top priority? Government dues get top priority, and this is called crown debt. That is what this case study highlight. Second case we have, Sirpur paper mill versus collector of central excise. See what happened in this particular case. Basically Sirpur paper mill, what it is all about. See, this case clarified a common confusion. Just because plant and machinery are fixed to the ground does not mean they are immovable property. Try to understand, very very important. Plant, machinery, they are fixed to the ground. It does not mean that they are immovable property, right? What really matter is purpose. If the installation is for better performance and not permanent use, it is considered movable. Try to understand how to compare movable and immovable. This was cleared by this particular case, Sirpur paper mill versus collector of central excise. This case study shows that just because anything that is fixed to the ground like plant and machinery does not mean that they are immovable property. What really matter is the purpose. Purpose always matter, right? If the installation is for better performance and not permanent use, if the installation is for better performance, better functioning, and not for permanent use, that particular installation is considered movable, right? So this means excise duty is applicable on that. That is the point, right? That is central excise duty. So I hope these two case studies are clear. Now have a look at the next point, that is RTI Act. So these two topics which we have, the first chapter we have completed. Now have a look at the RTI Act, right? So basically, to the context of the previous slide, the court used legal tests from the Transfer of Property Act and other law to reach this conclusion, right? So these cases help us understand that how the law treat debt, transfer and property in very specific practical way. Now let's explore the Right to Information Act, commonly known as RTI Act, a powerful tool that empower every citizen to hold the government accountable. Now first of all, what is the RTI Act? So basically, the RTI Act allow you to request and access any information from the public authority. This include file, email, memos, report, record, sample, and even digital format like printout or tapes. Now question is, who does it apply to? Yes, very very important question. Let me show you who does it apply to. So here you can see it applies to all public authority, right? These are who are public authority. These are the body established or funded by the government. So it includes ministry, it includes someone who is funded by the government, right? Ministries, department, even NGOs, right? Non-governmental organizations that are substantially financed by the government. So to all these cases the public authority apply. Now the question is, what kind of information? Yes, have a look at it. What kind of information can be accessed? Any material in any form, like from document to email, from even private data. So these things can be, you can see any material, record, doc, memo, email, order, report, sample, electronic data can also be accessed, right? So any material in any form. Now what are your right under RTI Act? Yes, have a look at it. Right to info. So you have the right to inspect the, here you can see, you have the right to inspect the record, you have the right to take notes or certified copies, you have the right to get certified samples, and you have the right to receive information in digital format. So these are your rights. So your rights include inspection of work, taking notes, getting certified sample, and receiving information in digital format. Now the question is, who is responsible for providing this info? Very very important. See, each public authority designate a CPIO or PIO, whatever we call it, central info. So have a look at it. CPIO, CPIO is basically central public, here you can see central PIO, which means central public information authority officer. So each public authority designate a CPIO, that is called Central Public Information Officer, and this officer process your RTI request. And at the top we have Central Information Commission, which is formed by the central government to ensure transparency and compliance. So Central Information Commission is formed by the central government to ensure transparency and compliance, and Central PIO, they are designated, they process your RTI request. So friends, if you want such kind of videos where each and every things explained in the form of mind map, flow chart, so that you can revise easily, you can enroll in our crash course program. This crash course program is designed to offer you quick and concise notes that you can easily revise. Now one more thing is appropriate government. Try to understand. right? Central government is responsible if the authority is controlled or funded by the union, funded by it or the union ministry. See, when central government is responsible, central government is responsible if the authority is controlled or funded by it or union territory, and state government is responsible, state government takes charge for a state level public body. So basically this, first of all, let's start with the RTI request. Let's understand how to make a request under the RTI. So RTI, basic thing we have already discussed in the unit number 31, I think. Yes, we have discussed. Now RTI request, let's start with. First of all, PIO. What is PIO? Public Information Officer. So PIO is our point of contact. So their duty is to accept our RTI application and even help you write it if needed. So PIO is the first point of contact, is also called point of contact, right? So their duty is to accept your RTI application and even help you write if needed. Now if your request is not related to their department, try to understand, if the request is not related to their department, the PIO must transfer it to the correct department within 5 days. Very, very important. If the request is not related to their department, I told you na, every department have a PIO, right? So this is they are the point of contact. If the request is not related to their department, they must transfer it to the correct department within 5 days. The PIO can seek assistance from other officer. They can require assistance from other officer, right? If required to process your request, if they require to process your request, they can seek assistance, they can seek help from other officer. Now you will receive a response within 30 days, either with the information you asked for a valid reason, right? So basically response time is 30 days. 30 days is the response time, either with the information you asked for a valid reason or a valid reason. In urgent case where life and liberty is at stake, the response must come within 48 hours. And yes, after you pay the prescribed fee, the requested information will be shared. So this process ensure clear transparency, accountability, and a citizen right to know, clear, time bound, and effective. So these are the important dates: transfer within 5 days, respond within 30 days. In case of urgency, so in the case of urgency, reply in 48 hours. So these things you must know. Who is PIO? What is his duty? We must understand it. Now let's look at RTI section 32.4, which is regarding the disposal of request. So first of all, how your request is handled, that is all about disposal of request. See, when you file an RTI request, here is what it happened next. First of all, something called deemed refusal. So if no reply come within the time limit, your request is treated as rejected. So that is the point. If there is no reply in time, the request is considered rejected. Second, see, deemed refusal means what? If no reply come within the time limit, first of all you file the RTI request. So if no reply come within the time limit, what happen? In that case your request is rejected, right? Now rejection notice, which means if your request is denied, a proper reason must be given along with how to appeal and who to contact. That is called rejection notice. First of all, no reply come, your request is rejected. If your request is denied, a proper reason must be given along with how to appeal and who to contact. Now the form of information, that information should be shared in the format you asked for, unless it is too difficult or a safety issue. If it is too difficult or it is a safety issue, then it cannot be, but the information should be shared in the format that you asked for. Then partial disclosure, if only part of the information is shared, you will get an explanation, the officer detail, and the cost involved, right? So that is called partial disclosure. Then we have third party information. Try to understand, if your request affect another party, they will be informed within 5 days and must reply within 10 days. So suppose if your request affect another party, so they will be informed, the third party will be informed within 5 days and they must reply within 10 days. Then we have fee payment. You will need to pay ₹10 through cash, demand draft, check, or IPO addressed to the account officer. Then transfer case, if your request goes to the wrong department, it must be transferred within 30 days, and the new department, so I think we have discussed it already, so transfer should be done within 5 days, right? Within 5 days transfer will be done, and the new department should reply within 30 days. And then information charge, I already told you, any extra charge will follow the RTI fee rule. So these are the important points. Just let me remind you once more. First of all, what we talked about the deemed refusal. If no reply come within the time limit, your request is rejected. Rejection notice. If your request is denied, a proper reason must be given. Form of information. This information should be shared in the format partial disclosure. If only part of the information is shared, you will get an explanation. Third party information. If your request affect another party, they will be informed within 5 days and must reply within 10 days. Fee payment. You will need to pay ₹10 through the cash. So these are the important points. Now have a look at this. That is called RTI section 32.4, fees, third party rejection and assumptions. Very important point. So when you file an RTI application, there are few key things that you need to know. First of all, RTI fee structure. I think you know it. You may need to pay a small fee like per page printing or inspection cost, but don't worry. The time it takes to tell you about the fee is not counted in the reply deadline. Third party information. If you request information about something as data, they must be notified first. Yes, your information is being shared. So they must, I told you about already, third party information if you are accessing, they must be notified first. There is a clear process with timeline to protect their right. Then we have request rejection ground, means rejection reason. Not every RTI can be accepted. If it is denied, maybe due to copyright or legal limit, the officer must explain why, when and how you can appeal. So the rejection reason, it must be given, because every RTI cannot be accepted. If RTI is denied due to copyright or legal limit, the officer must explain why it is denied, right? And then we have section 8 exemption. Some information is off limit under the law. This include matter of national security, sensitive trade data, or anything that can harm the national interest. So these are exemption. So RTI empower you with access to public authority, right? So basically, but with fair rule to ensure privacy and security for all. So that is all section 8 is all about. Now friends, have a look at the next slide. Next slide is penalty and disciplinary action. Very important, right? So when public officials fail in their RTI duty, there are serious consequences to ensure accountability, right? So what can happen? First of all, monetary penalty. So a fine of ₹250 per day is charged for every delay in providing information. How much? ₹250 per day is charged for every delay in providing information, up to ₹25,000. But first a hearing is held to give a fair chance to respond. So fine per day ₹250 and up to 25,000. This is the monetary penalty. Then we have failure to accept. So simply refusing an RTI request without any valid reason, that is not allowed. Late delivery. See, if the information reaches you after the deadline, it counts as what we have just discussed. Fine of ₹250 per day up to maximum 25,000. If you failure to accept, then simply refusing is not acceptable. Late delivery, then it is counted as violation. Then we have malified denial. Suppose in bad faith or with wrong intention denying an RTI, this lead to penalty. Or incorrect information means giving false or misleading information is taken very seriously. And destruction, if someone destroy the requested information to avoid sharing it, that is a major offense. And obstruction, creating unnecessary hurdle in giving out information, is also punishable. So these are the penalties, right? Now have a look at the IT Act. So very important thing. So now we have discussed RTI. Now let's look at IT Act. Let's simplify some key terms under there are some terms under IT Act. Let's have a look. First of all, we have cyber security, which means this protecting from hacker or unauthorized access to your computer system. Then we have access. Access means ability to enter or use computer system or network. Addressee is the person who is supposed to receive the electronic communication. Adjudicating officer. See, any officer who handle legal issue under this law are called adjudicating officer. Appellate tribunal, a special court to hear appeal related to the IT law. Digital signature, so a secure way to sign digital document proving authenticity. Then we have appropriate government, so the central or state government that oversees or that monitor the compliance under this act. Asymmetric crypto system, a secure system that use public and private key to keep your data safe. Certifying authority means these are the licensed entity that issue digital signature, because there are the certifying authority are the entities that issue the digital signature. Then we have certification practice statement, a document showing how certifying authority maintain trust and follow the rules. Then we have computer, any device that process data like your laptop or server. Computer network, it is a system of connected computer that share information. Computer resource, this include everything like hardware, software, data, system, everything. Computer system, these are the device that can store, that can retrieve, that can process the data. And then we have controller, means the regulator who monitor all the certifying authority. So all the certifying authority are monitored by regulator. Sometimes question are asked, who is controller, who is certifying authority, who is executing officer, who is appellate tribunal. So these things so basically the section of IT Act help define role and tools used to manage digital identity, data security, and how we handle information online. Now let's have a look at the unauthorized act in the cyberspace in the next slide. So unauthorized act, so basically when we use the internet or digital system, there are strict rules about what is allowed and what is not allowed. So let's walk through some actions that are considered unauthorized and illegal in the cyberspace. First of all, we have access. If someone enter a computer, network or system without permission, so that is illegal. Suppose someone enter network, computer or system without permission, that is illegal. Download and copy, so taking data, taking information without permission even into USB or hard drive is a cyber offense. Inject virus, so spreading virus or harmful software into system can damage or steal data. Then we have damage, any intentional harm to the system, data or software is strictly prohibited. Disruption, interrupting the normal functioning of a computer is a punishable act. Then we have deny access, so blocking rightful user from accessing system or data is an offense. Assist breach, helping someone hack or access system illegally, so this is also a kind of unauthorized act. And then we have delete data, right? Delete data means delete or alter, which means that destroying or changing data without permission, that is a big no. Bill fraud, if someone tampers with data to cheat or reduce the bill, that is a fraud. And then we have source code theft, so stealing or modifying the source code of software is in the digital world is also a theft. So remember, cyberspace may be virtual, but the consequence of breaking the law are very real, and that is all we need to know from these 2 units, right? So if you want such kind of PDF, you can enroll in our crash course program for more detail. Thank you.